Maureen Thomas. How can we help you? You need to unmute. Is that a victim or a witness of some sort?
Witness in the Matthew Weller case, Your Honor.
Why is she on my Zoom?
I have no idea.
Your Honor, I believe you had this come before your court back in December of last year. I believe defense counsel in this case objected to Ms. Thompson giving testimony via Zoom. So at this time, we are going to ask that she be given another opportunity to come.
We're not on the record, so.
But she is a
Was she subpoenaed her? Was my question.
Our office.
To appear in person?
Yes.
Okay.
Yes.
Ms. Thomas, please unmute your device. On the record in the matter of the State of Michigan versus Matthew Weller, 25-03259. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the State of Michigan.
Your Honor, Josh Kuiper, P66576 on behalf of Matthew Weller.
Okay, Ms. Weller, you need to, Ms. Thomas, you need to unmute your device. I don't even know if she can hear us. She's just sitting there. Today was the date that was scheduled for a preliminary examination. As preliminary examinations are held in person and witnesses were supposed to appear in person. I don't know why Ms. Thomas is here.
Give just a bit of procedural background. My client was arrested, posted bond, I believe, in November of 2025. We initially had a preliminary examination scheduled for January 30th, 2026. I had a scheduling conflict and the prosecutor's office was kind enough to grant adjournment till March 5th, 2025. And at that time, we conceded to an adjournment because Ms. Thomas was not going to appear in person. And so here we are, April 9th, almost 6 months after my client was arrested. We're prepared to go forward with the preliminary examination and expected her to be in person. I finished a trial yesterday and I had an email from Mr. Smith asking if Ms. Thomas could appear by Zoom. We would like to conduct this preliminary examination in person.
So they're required to be in person. I don't know why Ms. Thomas is present via Zoom when she was supposed to be here in person. My note here from January 30th is that the victim contacted the prosecutor's office and said she was in Florida. So she was supposed to appear in person. She's via Zoom. She's not even responding to my request to unmute herself. Was seemingly smiling and making faces at the computer while you were talking. So you're not prepared to proceed.
We're not prepared to proceed. She's clearly in Florida. We're asking that the court adjourn this one more time to allow her to appear via in person. Again, I believe at that time, if she's unable to appear via person, we would ask that it be dismissed. So we're asking the court for one more opportunity to run this hearing.
Your Honor, we would respectfully request that you dismiss the case. We understand that that would be without prejudice and the prosecutor's office reissue charges. However, this is the third date for the preliminary examination. On the March 5th date, we did acquiesce to an adjournment due to her inability to appear in person. We knew she was in Florida at that time. We're at this particular time inconvenience to my client and we're prepared to proceed. And this is the third date for preliminary examination.
Agreed. The motion to dismiss is granted without prejudice. Not only did she not follow the order of the court, she's not even technically here because we can't communicate with her at all. If she decides to appear and ready to proceed, then they can reissue the charge against you. And then you'll have to be arraigned. It looks like you're on GPS tether. You can go and have that removed if you have not already.
Your Honor, I believe we addressed it at a prior hearing.
Okay,
That was removed. Thank you.
Okay, sounds good. Any additional matters for the record?
No, wrong people.
None from the defense. Thank you.
You're all set. Let me get you a copy of this, Mr. Bill. State of Michigan versus Elias Griffin, 26-00744. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, on behalf of the people.
Jacob Riley on behalf of Mr. Griffin, who's not present.
We had communication with him.
I have nothing.
I knew he was supposed to reapply and he did, and your office is going to represent him.
That's correct. We've not been able to establish contact since it's time to represent.
I'll sure thank you. Okay, and McCroy Stump is downstairs, correct?
Yes, Judge.
To be brought up. State of Michigan versus Devon Robinson Johnson, 25-01903. Appearance, please.
I thank Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Good morning, Your Honor. Brendan Basile with on behalf of Mr. Alonso Robinson Johnson. He is standing to my right at the council table.
This matter was scheduled today for preliminary examination. This is for carrying concealed weapon, possession by prohibited person, and a weapons charge. Are we running an exam today?
Your Honor, I believe the people will be prepared to run the exam. We are actually waiting on a certified copy of Mr. Robinson's
Conviction.
conviction. So barring
Not an
that,
issue.
we would be-
That's not an issue.
Not an issue?
No.
Then if that's not an issue, then we'll prepare to run the exam.
Well, Your Honor, we're prepared to run the exam. I guess we'll address the prior criminal history when it gets done.
The court will absolutely, if we need to adjourn it or continue it, I should say, just to get a copy of it. So it's not going to stop the exam.
Understood.
Okay.
We're prepared.
Okay, I'll call the case in just a moment. Ms. Thomas?
Yes, I'm here.
Okay, you were supposed to be in person at the court.
Yeah, I live in Florida now and I work here and I was unable to get it off work long enough to come up there.
Okay, well, you need to contact the prosecutor's office because of your failure to appear in person for the purposes of a preliminary examination. The case was dismissed.
Of course it was. They weren't really trying to prosecute him anyways. No one contacted me until yesterday.
You did not get a subpoena until yesterday?
No one even subpoenaed me. No one called me, nothing. Yesterday was the first call I got. And I
Okay.
answered it and spoke to them and said, hey, I'll come up there. I just need the time to tell my work.
Okay, yeah, it's unfortunate because you definitely should have been notified prior to yesterday, so considering you don't live in the state. You would need to contact the prosecutor's office because if you want this prosecuted, they'll reissue the charge.
Okay, I do.
But you have to understand that you do have to appear in person. I do also understand that you need to be notified prior to the day before. So you
Okay.
contact the prosecutor's office and speak to the district court supervisor and advise of your concern.
Okay, do you happen to have a name of who that would be?
He just walked in the courtroom. Joel Martinez, asked to speak for
Okay.
him.
Okay, thank you. I will write that down.
Thank you.
Thank you. I appreciate your
Alright,
time. Have a good day.
Thank you. Thank you, Mr. Martinez. That was on the Weller case.
Okay.
I know you're just walking in. The case was just dismissed 10 minutes, not even 10 minutes ago, because Ms. Thomas failed to appear in person for exam. She has just notified the court that she wasn't notified that she needed to be here until yesterday. She lives in Florida,
Oh, got it. Okay,
and she would like the case be prosecuted. So I told her to contact your office and express her concern.
absolutely. Ms. Thomas, if you can, my name is Joel Martinez. I'm one of the supervisors at the prosecutor's office. If you can contact my office, ask for me, and I'll speak to you about the case, and we'll see how we can get this reissued and move it forward, okay?
Okay, thank you. I appreciate that. Thank you. I will.
Yes, ma'am. My apologies for everything that went on this morning. Sorry.
Thank you.
Let me see. We didn't see him, Mr. I don't have Mr. Green. Mr. Green, who are you representing? Oh, I see you. Are you representing Mr. Cadet?
I am, Your Honor, yes.
Okay, this is State of Michigan versus Mardochi Cadet 26-00748. Have a Perez, please.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith appear on behalf of the people.
And good morning, Your Honor. Vince Green, on behalf of the defendant, Mr. Cadet, who's appearing by Zoom along with myself.
Okay, I did indicate last time that we would treat today as another probable cause conference because the defendant was going to retain you for representation. Have you received discovery yet?
We have not, Your Honor, but I know the prosecutor's office is very efficient in getting us discovery, so I'm sure we'll have it soon.
Okay, so we just need to get you a new date for exam.
Correct. And I think Mr. Cadet needs to waive his 21 days, according to my notes from Addie Nash. So, yeah.
Absolutely. Mr. Cadet, you had the right to have an exam within 21 days of the date that you were arraigned. It looks like you were denied a court-appointed counsel, and you indicated that you intended to retain your own counsel back on April 2nd. So we're not able to proceed today because your new attorney needs to get discovery and then help prepare for your defense. Due to that, are you willing to waive the 21-day timeline so this could be reset?
Yes, I am.
Does May 7th work at 9?
Let's see. That works just fine, Your Honor.
Okay, we'll continue to examine that date and time. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
Thank you. So I think George is coming. Okay, I don't see George in here though, unless he's behind this. He's not. Okay, is Magana here? Your other client? George is here for Etheridge's matter.
Yes, sir.
Okay, Christopher Ford present.
Yep.
State of Michigan versus Christopher Ford 23-01253. Here it's for the record, please.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Georgia at 8 p.m. I have my class in. All right.
Okay, Mr. Ford has a carrying concealed weapon in possession by felon and felony firearm, second habitual offender notice. How are we proceeding on this?
Your Honor, at this time, we're asking for an adjournment. Our office is actually referring this case to the federal, to the feds because of the nature of the facts and circumstances here. So we ask that this matter be adjourned.
I'd be objective to the adjournment. Me and my client were preparing all day yesterday, or quite a bit yesterday in regards to today. We were ready
I was gonna say all day.
all day, but a couple hours over the phone. We were prepared and ready to proceed today. We objected to any adjournment.
Objection is noted. Case will be adjourned. for the purposes of a referral to the federal government for prosecution. Any additional matters for today's record?
Nothing from the people, Your Honor.
Let me get you the date.
May 7th at 9:30.
For the record, the court's finding good cause to go beyond the 21 days. So May 7th.
Second.
If we're gonna kick it out, can we kick it out a little further? My client wants to get some affairs in order, in case it does go to the federal.
We're not holding an exam here, so it doesn't matter.
Right.
It's really about how long do they need to get it transferred to the federal government. So,
In case they don't.
okay, in case they don't,
If we get more time for the preliminary examination, further than May 7th.
that's fine. I mean, it's been since, this is 2023 file. He's got to get more things in order. No, you know now,
No, I don't know. I didn't.
right?
Well,
But you're saying, and you claim you were prepared today, but you won't be prepared May 7th.
We were prepared for the exam to go in our favor today, based on the evidence.
Okay,
And
but May
we found out-
7th, you're not prepared for it to do that.
We're prepared, but given the circumstances that he may be going to the feds, he has to get some things, he has a daughter, and I believe a son.
Yes.
So he has to figure out some things, because
He's got to figure that out regardless. The feds could take this case next week. We have no control over what the federal government, this date is not controlling that.
right,
So I'm not putting it out for that purpose. The state won't control what the federal government's gonna do. So if you guys get stuff together because you may be dealing with the federal, you might want to act expeditiously. This May 7th date has nothing to do with that. And more likely than not, if they haven't yet had this moved to the federal government, I'm just gonna get an email from the attorneys to adjourn it anyways. This is just a placeholder date. It's not gonna be, and I'm gonna actually have it set for a probable cause conference and not an exam.
they appear via Zoom.
Absolutely. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing further, Your Honor.
Okay, you're all set. This is McCroy Stump,
Yes, Your Honor.
of the state of Michigan versus Kamari McCroy Stump, 26-00743. Appearance, please.
Thank you, Your Honor. May it please support Assistant Prosecuting Attorney Dan Smith here on behalf of the people of the state of Michigan.
Erin Robinson, Assistant Public Defender for Mr. McCroy Stump.
He has a receiving concealing vehicle, a police officer assault, and police officer fleeing eluding. My understanding is that he does not wish to have a preliminary examination.
That's correct. He's waiving his preliminary exam today.
Okay, it looks like we have another file here. This is state of Michigan versus Kamari McCroy Stump. This is 26-00837. It's in warrant status. So I need to arraign him. I do have a felony complaint here that alleges that on or about February 16th, 2026, that you did allegedly commit the act of count 1 of stolen property, receiving, concealing a motor vehicle. And that you did that allegedly at the address of 6200 South Martin Luther King Boulevard, Lansing, Michigan. And allegedly, it says a defendant convicted of this charge may not be convicted of another subsection of MCL 750.535 for the same conduct. But that you did allegedly buy, receive, possess, conceal, or aid in the concealment of a blue Kia sedan, a motor vehicle that was stolen or knowing or have reason to know was stolen, or believe that the vehicle was stolen, embezzled, or converted, that this was in violation of Michigan Compiled Law 750.3537. That's a felony. Maximum penalty is 5 years in prison and or $10,000 in fines, or 3 times the value of the motor vehicle, whichever is greater. There's a count 2 of assault and battery alleging that on or about February 16, 2026, at 6200 South Martin Luther King Boulevard, that you did allegedly make an assault or assault and battery upon a Mackenzie Pope, and that this was contrary to MCL 750.811. It's a misdemeanor, maximum penalty 93 days in jail and or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the charges and the maximum penalty? You do have the right to an attorney. Your attorney on the other matters for today, for the purposes also on this file for an arraignment. You have the right to have an attorney to do all of your future court dates on this matter, and the right to be represented by an attorney if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the public defender's office appointed at the expense of the public. Do you understand that? You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty, not guilty, or stand mute. If you stand mute, this matter will go all the way through each stage to a jury trial. Count 1 is a felony. You have the right in that felony to have a preliminary examination within 21 days of today's date, unless you waive the timeline or the court finds good cause to go beyond that 21 days. You have the right at the time of preliminary examination to require the prosecutor establish that they have sufficient probable cause that a felony was committed, and then probable cause sufficient to charge you as the person who committed the felony. You have the right to proceed to trial and the right to have a jury trial. You're presumed innocent until proven guilty. You can, at the time of trial, require the prosecutor prove each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent and not have silence be used against you. You have the right to see, hear, or question any witness called to testify against you. The right to subpoena witnesses to testify on your behalf. The right to waive your silence and testify at your own trial. Do you understand each of those rights? For the purposes of this arraignment, the court will enter a not guilty plea at this time. The matter is scheduled for probable cause conference on April 16th at 9 a.m. And then he'll have a preliminary examination that's also scheduled April 23rd at 9 a.m., both before me. So yes, this matter that we were scheduled for an exam today. There's a matter for 56A as well. Oh no, it's been bound over to the 56th Circuit Court pending as well. Is that correct? You don't know? You have any other court cases pending besides this one?
He has one in 30th Circuit, Judge. I didn't see one from 56 when I looked, but my system's not as.
I have his
thorough as
criminal
yours.
history here. It says he has a receiving concealing motor vehicle bound over to the 56th Circuit Court. I don't see a disposition on that. And then you said he has one.
He has an open case in 30th Circuit.
You can address bond.
Yes, Your Honor, we would ask for a reasonable 10% bond in this case for Mr. McCroy Stump. I know that he's not eligible for a personal recognizance bond at this time, but we would ask for a reasonable 10% bond. He does have family and ties in the community, and he is being actively monitored by 30th Circuit Court.
I do have a bond recommendation in the file from the prosecution's office. It says that there's a concern for the protection of the public. Because the defendant is either on parole, probation, or had other pending matters which we're aware of. And then the crime in this particular file involved or alleged violence against another person. And that the defendant has a record of non-appearance at court proceedings to avoid prosecution. The people in this file are requesting a bond of 25,000 cash surety with GPS tether. It says a 2,000 square foot exclusion zone with victim notification if possible to ensure the safety of the alleged victim in this matter. Which the initials are different from the name that I thought. Let's see here. I'm unclear why the initials here. Nonetheless, it says the defendant is out on felony filed before Judge Aquilina in file number 25-02774. Okay, so it's listing two victims here, that's why. Okay, it says that they're requesting a no contact order for Mackenzie Polk and Ophelia Perlberg. And a 25,000 cash surety bond. The defendant has, we know for sure, 3 cases now in this felony cases in this county alone. According to this criminal history report that I have here, possibly another in the 56th Circuit Court. He has pending same charges on all of them. I absolutely believe there's a threat to public safety, and he would have been out under supervision of the 30th Circuit Court when these allegations allegedly took place. So that's not reassuring, and his contacts to this community has not kept him from picking up or pending felonies at the same time. I'm going to grant the people's request for 25,000 cash surety bond with GPS tether. While on bond and while in custody of the court, these are your of the jail. These are your conditions. You're not to have contact directly or indirectly with either Mackenzie Polk or Ophelia Perlberg. You're not to be within 2,000 feet of wherever they are. You're not to cause a third party to communicate with them. You will wear GPS tether with victim notification. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to travel outside the state without prior approval of the court. You're not to use drugs or alcohol unless you have a valid prescription. You will report to pretrial services within 48 hours of your release from custody. Do you have any questions about your conditions of bond? I'm sorry? Oh. The court also is noting that you are requesting the public defender on this file as well. Okay, now that we've taken care of that, we have here, he's going to not have an exam on 26-00743.
That's correct.
Okay. And so are the people who are going to waive their right to exam as well?
Yes, Your Honor, that's correct.
Okay, and Mr. McCroy Stump, you understand your right to have a preliminary examination on the felony and your right to have the prosecutor establish sufficient probable cause that a felony was committed and probable cause sufficient to charge you as the person who committed the felony. Okay, you wish to unconditionally waive your exam? Is anyone promising you anything to do that? Any threats to get you to waive your exam on that file? Okay. And was there an offer or are you trying to do a global resolution on that?
The global resolution. Circuit. May I approach?
Yes, thank you. And your bind over date is going to be April 22nd. That's the date the circuit court is receiving the file from the district court. It's not a date that you have to appear in the circuit court. Your next court date will be a pre-trial in circuit court. Your attorney will be made aware of that date, okay? You have any questions at this time, sir?
No.
Bond was at a 3,010%. That will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
You're all set.
Judge, you want somebody else?
I'm sorry?
You want somebody else?
Oh, for sure. Let's see. Mr. Raleigh has some people that need to be brought up. Van Patton is a plea,
Yes, ma'am.
and then Dodge after that, and then House after that. Mr. Ford is next person. Is that what he's waiting for?
It might be still in the printer.
Jada go.
This printer under.
There's a printer under David's thing. Can you get the form that says it should be for?
Judge, can I see the new file for that one? Yeah.
See a date to appear for Kristen. Let me see what you got there. You can give that to Mr. Ford. So he's. Mr. Ford? Is he gone? Christopher Ford gone? I guess he's, yeah. You can call his name. He left. Okay. You can put it right here so they'll mail it to him. Take that off. Is Teodosio Magana here?
Yes.
Yes.
Okay. This is State of Michigan versus Teodosio Magana, 26-00742. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of
Aaron Robinson, Assistant Public Defender for Mr. Magana.
Okay, today was the date scheduled for preliminary examination. This is for child abuse fourth and a domestic violence third. Are we having an exam today?
But Your Honor, the people are not prepared to move forward with the exam today. The subpoenas have gone out on this case. We have reached out to the necessary witnesses that need to make an appearance for this case. and we have not heard back from them, so we're not prepared.
We would make a motion, Judge.
Motion to dismiss is granted without prejudice. The people have the right to reissue this against you. You understand that? Hang tight, we'll get you a copy of dismissal. Anthony Clark here.
Yeah.
In Michigan versus Anthony Clark, 26-00756, appearance please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Clark.
Mr. Clark is scheduled today for prelim, which is procuring concealed weapon. Are we running this examination?
Yes. People are prepared.
Okay. How many witnesses do you have?
2.
Call your witness.
You just asked for the rule, Judge.
Sequestration is ordered.
We'll call Officer Peter Howard to stand.
Oh, it was for him. That was what it was. I'm like, where do I want to stick it? What is this then? As it goes. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
You can have a seat. You can state your first and last name and spell both, please.
Peter Howard, Peterhoward.
You can proceed, counsel.
Morning, Officer Howard. How are you?
Good morning, how are you, sir?
Good. Are you currently employed?
Yes,
Where are you employed?
the city of Lansing with the police department,
And what is your assignment at that?
general patrol.
And how long have you been on in that assignment?
Approximately 12 years.
And I'm going to direct your attention to March 22nd of 2026. Were you on duty at that time?
I was.
And did your tour of duty take you to? It is.
Give me a moment.
North Lurch and.
I'm sorry, because he's just talking and I don't want to pick up in this. There's a microphone right here. Now, we can't hear what you're saying, but it goes through the system. So if you need a moment to talk to your attorney, you can ask for that, but otherwise you got to whisper, okay? You can continue.
Did your tour of duty on that day take you to North Lurch and East Michigan Avenue?
It did.
Was that approximately around 9:37 hours?
Yes.
And at that time, at that location, did you happen to come into contact with someone that brings you to court today?
Yes.
And who was that?
That was Anthony Clark, sir.
Can you point him out and describe an article of clothing?
Yep, he's to my left. He's wearing a white sweatshirt.
And can you tell us what happened when you arrived on location?
I saw a black Jaguar stop at the red light on Larch Street with no license plate on.
And when you saw no license plate, car stop, what did you do next?
I waited for lights turned green, checked to make sure there was no paper plate in the back window. And as the vehicle started moving, I moved over behind the car and performed the traffic stop.
Okay. And now that you have this car stopped, what happened next?
I stepped out of the car, made contact with the driver, and identified him as Anthony Clark. And informed him why I stopped the car, which was no license plate.
Okay. And then what happened next?
Continued to speak with Mr. Clark. He provided me with an ID card. He said there's no insurance on the car. He gave me a title that was signed, but not transferred to his name, so it was still in the previous owner's name. At that point, I proceeded with a civil infraction, no insurance investigation.
Okay. So the car wasn't registered to him?
Correct.
Okay. So after you got that information, what did you do next?
I had another officer come back me up. Again, the car was parked on a road in a travel lane with no insurance on it. My intention was to tow the car because it was not insured. He had stated it was uninsured. And also, when I ran the VIN number for the Jaguar in lien, it showed, which is our law enforcement information network. Also, the Secretary of State, the SOS, it came back EIV equals N, which means there's no insurance reported in the Secretary of State, which further my belief that there's no insurance on the vehicle at that time.
And now that you have him out of the vehicle, you're investigating it for no insurance. What's his demeanor at the time?
He was nervous. He was nervous, yeah.
All right. And then you said you had another officer with you. What's the name of that officer?
There's Officer Stelgis and also Officer Rotuno and Indicoffer arrived on scene as well.
Is it Officer Stelgis and who?
Officer Indicoffer and Officer Rotuno.
Can you spell Indicoffer, please?
INDELKOPFER is my best guess.
Thank you.
Okay. So now you have him out back of the car. There's no insurance. You're about to tow the car. What happens next?
So he wasn't in the back of the car. He was just standing on the side of the road.
He's standing in the back of his car.
Correct.
So
Yep.
he's not in your car yet.
No.
So what happens now? What happens now?
So I informed him I was going to tow the car. I had him step out. I was working on printing off the citation while Officer Stelgis was performing an inventory search of the car.
And after that, what happened?
Officer Stelgis located the firearm.
Did this and was he eventually arrested or?
He was.
So did that conclude your interaction with the defendant on that day?
No.
What happened next?
I transported him downtown where I eventually performed a short interview with him. I read him his Miranda rights and obtained a statement.
Right. And what did the defendant say in that statement?
He said that he was not aware that he was not allowed to have a gun because he's not on probation anymore. He said that his sister had given it to him the day prior. And he told me his sister's name. I believe it was Mecca Johnson. Potentially, I'd have to refresh myself. I believe that was the name. So he said he had put it under the passenger side, the front passenger seat, kind of in the back. Kind of, so driver's seat, passenger seat, kind of under the front passenger seat in the back. Is where he had the gun.
Yeah. And did you have any personal interaction with the gun?
No.
Okay. Were you on scene when the gun was located?
I was.
Okay. And to your knowledge, what officer located?
Officer Stelgis located.
So after you take him down, you Mirandize him, give him he gives the statement. What happens next?
He just goes back to the booking area or go back to the cell area, and I completed my report.
Right. And did that conclude your interaction with the defendant?
That concluded it.
Okay. And all this took place in the city of Lansing, right?
Yes.
And that's in Ingham County?
Correct.
The state of Michigan? Yes. All right. You have no further questions?
Cross-examine.
Officer Howard, you stated that you pulled my client over on North Larch in Michigan. Is that correct?
Yes.
Okay. And when you activated your lights and sirens, did he immediately stop?
He immediately pulled over to the side of the road. Yes.
Okay. And how many people were in the car with Mr. Clark?
Just him.
Just him.
Yeah.
Okay. When you approached the vehicle, were there any tints on the windows, anything like that?
I don't recall.
Okay. So you don't recall if you could see anything from inside the car based on where you were standing?
No. I could see in the car, but I don't remember if there was any tent. No.
All right. And have you come into contact with Mr. Clark before?
One prior time.
Okay. And do you remember when that was?
It was over the winter, a couple months ago.
Besides those statements to you that he said in lockup, did he make any other statements?
Initially, when I talked to him up on the traffic stop, I asked him if he had any firearms in the car. He said no. And there's some other just basic traffic stop questions.
Okay, besides those two statements, nothing else about the crime?
Not that I recall.
I have nothing further.
You redirect?
No redirect.
Thank you, Officer Howard.
People call Officer Sturgis to the stage.
You want to do it? Candidate. Solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
You can state your first and last name and spell both.
Tyler Stelgis, Tyler Steljes.
Thank you. Good to see.
Thank you, Officer Sturgis. Good morning.
Morning.
Are you currently employed?
Yes,
And where are you employed?
City of Lansing Police Department,
What's your assignment there?
a patrol police officer,
And how long have you been in that assignment?
just over 9 years.
And were you on duty on March 22nd of 2026?
Yes,
And did your tour of duty take you to North Lurch and East Michigan Avenue?
yes,
And during your tour of duty, do you see someone in the court that you interacted with at that time in that date and location?
yes.
And who was that?
Mr. Clark,
And can you just identify an article of clothing that he's wearing?
gray hoodie.
Your Honor, let the record reflect that the officer Stelgis has identified the defendant.
Objections?
No objections for purposes of preliminary exam.
Identification is noted.
And when you, was that in the city of Lansing
Yes,
in Ingham County,
yes,
state of Michigan?
yes.
And what happens when you arrive on scene?
I spoke with Officer Howard. He had conducted a traffic stop, and he had told me that he had intended on impounding, towing the vehicle.
Do you have an understanding of why the vehicle was going to be towed?
He had told me it was an unregistered motor vehicle and it was not currently insured.
So what happens when you arrive on scene?
Officer Howard removed the driver identified as Mr. Clark. He was made aware that the vehicle is going to be towed. I then conducted an inventory search of the vehicle.
And what's the standard procedure for an inventory search? Or why is that done?
Whenever we impound the vehicle, we would conduct an inventory search. That's for documentation of recording the contents in the vehicle.
Okay. And when you started to conduct this search, was there anything of evidentiary value that you found?
Yes, I located a black Glock handgun underneath the front passenger seat.
And when you were on scene, who all was there?
Officer Howard, Mr. Clark, Officer Indocopper, and Officer Ricciuno.
To your knowledge, the only individual that was driving the car or in possession of the car was the defendant.
Correct.
And what happened after you conducted your inventory search?
Once I discovered that there was a firearm located, I immediately handcuffed Mr. Clark, and he was taken into police custody.
What was his demeanor at that time?
I don't really remember. He seemed cooperative.
Did you do any further investigation in surrounding the gun, the location of the gun? What happened after you got the gun out of the car?
I continued to search the vehicle, and I turned the firearm over to Officer Crawford.
And did you have any more interaction with the defendant after you turned the firearm over?
Not that I remember.
All right, nothing further.
Cross-examination.
Officer Stelgis, excuse me. So you were the one that conducted the inventory search, correct?
Correct.
And when you were conducting that search, you stated that you found a Glock handgun under the front passenger seat, correct?
Correct.
Did you know anything special about the handgun?
I don't remember there being a magazine inserted in it or any ammunition.
Okay, so it was basically had an empty clip and empty magazine, correct? Yes.
Yes.
Okay. Did you find any other type of items that could be associated with a firearm?
No.
Did you find anything else inside the vehicle that was that belonged to Mr. Clark?
The only other thing I remember finding in the vehicle was diapers, boxes of diapers in the trunk.
Okay. And besides your involvement with the inventory search, did you ever speak to Mr. Clark?
I don't remember interviewing him or speaking to him really, no.
Okay. And when you conducted the inventory search, were you wearing your body worn camera?
Yes.
And it was on and working?
Yes.
Nothing further.
No, nothing, Your Honor.
Thank you, Officer Stelgis. Please proceed to argument.
Your Honor, at this time, I believe the people of the state of Michigan sufficiently established probable cause basis to find this case over. The defendant has been charged with carrying a concealed weapon on or about March 22nd, 2026. You heard testimony from the officers today that they stopped the defendant's vehicle, but because it did not have a license plate and wasn't registered. They then conducted a search of the vehicle because the vehicle did not have insurance and it was going to be towed. Subject to that inventory search, they located a firearm underneath the passenger seat of the vehicle. And you also heard testimony that from one of the officers that the defendant himself explained that he believed that he could have that firearm because it was legal and he was no longer on probation. The people must, in order to be found guilty of the crime of carrying a concealed weapon, the people must establish that the defendant did knowingly carry a concealed weapon in a vehicle operated by the defendant or occupied by the defendant. And I believe based on the testimony that we have established each element of that.
Yes, Your Honor, we would leave it in the court's discretion.
Today was a date scheduled for preliminary examination. The burden is on the prosecutors to establish sufficient probable cause that carrying concealed weapon, which is a felony, actually took place and that you were the defendant who allegedly took part in the carrying of concealed weapon. This is not a trial. They don't have to prove each element beyond a reasonable doubt. They just need more than mere suspicion, which in this case, the court is satisfied that they have more than mere suspicion based on the testimony first of Officer Peter Howard from Lansing Police Department. Again, on the date and time and question, March 22nd, 2026 at 9:37 in the area at or near North Larch and East Michigan. That makes venue in this court appropriate traffic stop was done. Court has no reason to believe that the traffic stop was inappropriate. It was for no license plate. It's possible the defendant had maybe just purchased the vehicle. Maybe that's why they didn't have a plate, but he produced an ID card. I noticed that it didn't say license, but that's a whole other issue. And that the car was titled, but not registered. At the time, there was no insurance. And so officer was going to have the vehicle towed due to the no insurance and the lack of registration. I believe that he did provide the defendant with a civil infraction or a citation at that time. In doing an inventory search, Officer Sturgis appeared and did perform that inventory search, which is procedural and prior to having a car towed. And in that time, they located a black box handgun underneath the passenger seat vehicle, to which later, when Officer Howard interviewed the defendant after what he said, he Mirandized, and the defendant admitted that he did have a firearm and that it was his. He thought he could carry it, and that his sister had given it to him the day before. This matter will be bound over to the circuit court as charged. Bind over date is April 22nd. That's the date the circuit court receives the file from the district court. You do not have a court appearance in the circuit court on April 22nd. You understand that, Mr. Clark?
Yes, ma'am.
Your next court date will be a pre-trial. Your attorney will be made aware of that date. So you stay in contact with Ms. Robinson, okay?
All right.
A bond at 2,000 personal recognizance will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
You're all set. This is the matter of the state of Michigan versus Jesse Van Patton, 26-00725. Appearance, please.
Thank you, Your Honor. May I please support Assistant Prosecuting Attorney Dan Smith, attorney on behalf of the people.
Thank you, Brian. Yes, Mr. Van Patten.
Mr. Van Patten had a police officer assault and an assault and battery. My understanding is that there was a plea offer today.
Yes.
What is the offer?
The author was the offer in this case was defendant was gonna plead to a domestic violence first offense, and we were gonna dismiss the resistant the article.
Let's count one and then count two to domestic violence.
First.
The client wishes to accept that offer.
To accept the offer.
Yes.
Okay, raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, you have the right in this matter to proceed to trial, the right to jury trial. At the time of trial, you have the presumption of innocence, so you're innocent until proven guilty. You understand that? You have the right to maintain your innocence. Require the prosecutor first prove your guilt beyond a reasonable doubt by going to jury trial. They'll have to prove each element of each of the charges at that time beyond a reasonable doubt. Do you understand that? You have the right to remain silent at any trial, and they can't use it against you. You have the right to see, hear, and cross-examine in court any witness called to testify against you, and the right to call witnesses that will testify on your behalf or present evidence that you believe show a defense to the charges being brought against you. You understand those rights? And you're willing to give up all of those rights?
Yes, sir.
Anyone promising you anything to get you to do that? Any threats being made to you to get you to plead guilty?
No.
Are you on probation or on parole?
No.
You understand that by pleading guilty, it can result in a conviction that you may need to report to a current or future employer. You don't understand that?
See if you understand what you said.
By pleading guilty, this could result in a conviction that you might need to put on a future job application.
Yes.
And if you're employed now, you might need to tell your boss about this conviction.
Yes.
Okay. It also can have impact on your ability to travel to different regions of the world. Do you understand that?
Yes, Your Honor.
Or if you're seeking some immigration status, this could impact that. Do you understand that?
Yes, Your Honor.
As to the amended count 2 of domestic violence, how do you plead?
Guilty.
Is that because you believe you're guilty? Factual basis, please.
Mr. Van Patten, on or about March 18th of 2026, were you in the area of 1921 Mary Avenue in Lansing?
Yes.
Is that in city of Lansing, Ingham County, state of Michigan?
Yes, Your Honor. Yes.
Was the individual named Rebecca Dodge also present at that location?
Yes. Yes.
And she's a family member who lived with you at that location, correct?
Yeah. Prior.
Well, at some point you did.
Excuse me?
You had a domestic relationship is the term they use.
Oh, yes, yes. Yes.
Okay. At some point on that date, did you do something that constituted an assault against Rebecca Dodge?
Yes.
So what did you do?
I shoved her walker.
You pushed her walker, and was she holding it at the time?
Yes.
Okay. And this caused her to be pushed back, so
Yeah.
made her stumble. And this isn't something that she invited you to do, and she wanted to have, it was an unwanted contact.
Yes.
And you were not acting in self-defense, correct?
No.
Thank you. I believe that's the factual basis.
Any questions from the prosecutor?
People are satisfied.
Or is also satisfied with the factual basis of finding you voluntarily and intelligently made. This matter is scheduled for sentencing May 29th at 9 o'clock in the morning. You're gonna need to meet with probation so they can provide the court with a pre-sentence interview and how a recommendation of how they believe you should be sentenced. I'm sure he's supposed to be, if postponed, on a spam tether, I'm assuming. That's noted here, but there must be some underlying concern about a substance abuse. So I'm going to order the substance abuse assessment prior to his sentencing. Any additional matters for today's record?
Nothing wrong with people, Your Honor.
May I actually address bond actually, Your Honor?
You may.
I believe the amount of bond he has right now is $7,500, 10%. So in other words, the cost to him would be $750, and it's not an amount that we realistically afford, given that he has pled to a misdemeanor. At this point, my request would be for a PR or significantly lower 10% bond at this time. He does have a place that he can live that would be separate and apart from the victim in this case.
Where's that?
2027 Mount Hope, I believe that's his cousin's residence.
2027 Mount Hope. What's your phone number?
517-480-3627.
3627.
Yes.
I'll amend the bond to 7,500 personal recognizance with GPS tether and stamp. So it's going to attest, and you're not to be within 2,000 feet of Rebecca Dodge. Do you have any questions about that?
Any questions?
You need to report to all your future court dates. You also need to report to our probation department no later than Monday at 10:45 in person. Do you have any questions about your bond conditions? Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, but would you like the advice of rights?
I would not. Thank you. He's sick. All set. You can bring up Dodge.
Your Honor, can I approach?
Where are you approaching? Do I need
Oh,
a
no,
prosecutor?
it's just
Oh,
an interesting
okay.
bit of trivia.
We were on the record in the matter of the people of the state of Michigan versus Jaden Dodge, 26-000750. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Jacob Riley on behalf of Mr. Dodge, who is present to your right.
Mr. Dodge is here today for a police officer assault, preliminary examination. My understanding is that there will not be an exam today.
That's correct, Your Honor. We have reached a plea agreement with client intends to enter a plea.
We have offered to amend this charge down to an attempted RNO, which I believe the defendant has agreed to enter guilty plea.
Is that correct, Mr. Dodge?
Yeah.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
You can put your hand down. You have the right to proceed to trial and the right to a jury trial in this matter. You are presumed innocent until proven guilty. You can maintain your innocence and require the prosecutor to prove your guilt beyond a reasonable doubt. You understand that?
Yeah.
At the time of any trial, you have the right to see, hear, or question any witness called to testify against you. You can subpoena witnesses that will testify on your behalf, and you can remain silent and not have it be used against you. You understand each of those rights?
Yeah.
You're willing to waive them today?
Yes.
Anyone threatening you to do that?
No.
Any promises to get you to waive your right to plead guilty?
No.
You do have other matters pending, but you're not on probation, correct?
No.
Okay, you understand? I'm sorry?
I'm gonna say yes.
Okay, okay, and you understand that by pleading guilty, it could result in a conviction that you might need to report to your current or future employer.
Yeah.
It could also have impact on where you can travel or get immigration status.
Yeah.
As to attempted resist obstruct an officer, how do you plead?
Guilty.
Is that because you believe you're guilty?
Yes.
Factual basis?
Mr. Dodge, under about March 21st of 2026, were you in the area of 1430 Waymouth Court?
Yeah.
And in the city of Lansing, state of Michigan?
Yeah.
At or near that location, did you have some contact with police officers?
Yeah.
Is it true that they were wearing police uniforms and you understood that they were police at that time?
Yeah.
And were you aware that they were, that they intended to detain you and possibly arrest you?
Yeah.
Is it true that you did not comply with their commands to surrender and you tried to run away from them?
Yeah.
But they did eventually catch up to you and you were arrested, correct? Thank you.
Any questions from the prosecution?
Nothing from the people. No. Was that in the city of Bingham? County of, city of Lansing?
City of Lansing, Ingham County.
Yeah.
Court is satisfied with the factual basis. I'll accept your plea. I find it to be freely, voluntarily, and intelligently made. This matter is scheduled for sentencing May 29th at 9 a.m. You'll meet with our probation department so they can prepare you for a pre-sentence interview. Do you have any questions at this time?
So, well, I'm gonna be put on probation for this charge?
I don't know how you're gonna be sentenced. You're
Okay.
gonna meet with probation because they do the interview for your pre-sentence report,
Okay.
not because you're gonna be on probation. I don't know that you're on probation, okay?
All right.
Do you have any other questions? Any additional matters for the record?
Nothing from the people.
No, Your Honor.
You're all set. We have one more in custody. Is it House?
House.
Did you bring him up next? No, we have two more in custody.
Yes.
Yeah, everybody in Raleigh is represented.
Well, I have House and Shulumba.
What's your name, sir?
Warren.
Did they bring us the file?
Lindsay's doing it. She,
So.
Did you do a bench warrant hold for Perez or did you issue?
I did a visual. City of Lansing versus Dakari Hughes. I have 24-01824 and then 24-01-23092 here, Mr. Dakari Hughes.
Yes, Your Honor.
Okay, looks like he was supposed to be here earlier this week. OWI, he was supposed to be here on April 6th. And then there was a failure to display ops that he was supposed to be here also on April 6th. What happened?
I confused the dates, Your Honor.
You confused 6 with 9.
Yes, Your Honor.
Okay, looks like you have some other matters here. What's going on here? There is a City of Lansing versus Sakari Hughes 25L2959721 and 22. This is an equipment violation and an expired plate. You owe 198 on the equipment violation. You owe 198 on the expired plate. When do you intend to pay those?
I thought that I paid one of them, but if I can start a payment, then I can start as soon as possible.
We don't have any record of payment on here at all.
I can start, if I can get a payment, when I can start as soon as possible. Your Honor.
How much you gotta pay and when are you making your first payment?
$100.
$100 when?
Can I pay it today, Your Honor?
Okay, when's your next payment? Next month?
Yes.
I'll note that you'll pay $100 per month until paid in full. The total for these two amount to $400, just about. So we'll get you over to the traffic window after this. You can take care of your payment today as it relates to the OWI, and then the failure to display ops. It looks like that was previously adjourned so that you could, you and your attorney could work on negotiations. You need to make contact with your attorney, okay?
Yes, Your Honor.
What's your phone number?
517-237-2001.
Your number's changed many times in this file, and so that would be why your attorney doesn't have your number.
Yes, Your Honor.
So you need to call your attorney so they can have a way to get in contact with you prior to your next court date. But this matter's been reset or both matters, for May 4th at 11 a.m., okay?
Yes, Your
I'll
Honor.
reinstate your bond, you're all set.
Thank you, Your Honor.
You're welcome. Sir,
Wait for
notices. Sir, you can have a seat. You're all set on the record. Have a seat. We're gonna get you notices, and then I also need to get you to the counter, okay?
Yes, Your Honor.
Thank you. You got security coming?
Yeah.
Okay, and this is Mr. House. State of Michigan versus Nathan House. So this is 266-00749. Appearance, please.
Thank you, Your Honor. May I please support Assistant Prosecuting Attorney James Smith, appearing on behalf of the State of Michigan.
Jacob Riley on behalf of Mr. House, who is present tonight.
Okay, this is a police officer assault. My understanding is there's a plea.
Yes, Your Honor.
Yes, the people have agreed to amend this charge down to an attempted RNO, and we understand that the defendant's going to enter a guilty plea.
That's correct, counsel.
Yes, Your Honor.
That's correct, Mr. House.
Yes.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
You can put your hand down. You have the right to proceed to jury trial. You're presumed innocent in this matter until the prosecution can prove your guilt beyond a reasonable doubt. You understand that?
Yes.
You want to unconditionally waive that right?
Yes.
Okay, you also have the right to proceed to trial. Again, maintain silence and not have sounds be used against you. You have the right to see, hear, or question any witness called to testify against you, and the right to call witnesses that will testify on your behalf. You understand that?
Yes.
You can also waive your silence and testify at your own trial if you'd like. You understand that?
Yes.
Anyone promising you anything to get you to waive these rights and plead guilty?
Yes.
Who's promising you something?
Oh, no, I'm sorry.
Anyone threatening you to get you to waive these rights and plead guilty?
No.
Okay. Are you on probation or on parole?
No.
You understand that by pleading guilty, it could result in the conviction that you may need to report to a future or current employer.
Yes,
It also could have impact on where you can travel or get immigration status.
yes,
As to the attempted resisting obstructing officer, how do you plead?
guilty,
Is that because you believe you're guilty?
yes.
Actual basis.
Mr. House, on or about March 22nd, 2026, were you at the location 3001 South Washington Avenue?
Yes.
Is this in the city of Lansing, Buchanan County, and the state of Michigan?
Yes.
While at that location, did you have some contact with police officers?
Yes.
Ensure that they were wearing uniforms and they identified themselves as police, that you understood them to be police officers.
Yes.
Become aware that they intended to arrest you for an outstanding warrant.
Yes.
Is it true that you did not comply with their demands to surrender and that you tried to avoid being taken into custody?
Yes.
But they did eventually take you into custody.
Yes.
Thank
Was that in the city of Lansing in Ingham County, state of Michigan? Yes. People have nothing further.
The court is satisfied with the factual basis on accept your plea. Find it to be freely, voluntarily, and intelligently made. The sentencing date is going to be May 28th at 9 a.m. You'll meet with our probation department so that they can prepare a pre-sentence report and recommendation on how you should be sentenced. My understanding is that he's still working through some holes through Eaton Rapids. Is that accurate?
It's through Buchanan County, yes, Your Honor. He has a pending case. There's more than one case at this point.
This one case.
Just one case, which he expects to be resolved by May.
Yeah, I expect it to be resolved.
Any additional matters for today's record?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set. Thank you. Let's see, we're ready on Mr. Robinson's exam. Correct?
We are prepared.
Okay, you can get set up and I'll be right back. Okay, you do me a favor and get my phone. On my desk. On the record, in the matter of the state of Michigan versus the Tate, so Devontae, is that correct?
Yes, ma'am.
Robinson Johnson, 25-01903. Permission. Appearances, please, sorry.
Thank you, Your Honor. May it please report. Assistant Prosecutor Attorney Dan Smith appear on behalf of the people of the state of Michigan.
Morning, Your Honor. Brendan Vassie with on behalf of Mr. Devontae Robinson Johnson. He is standing to my right at counsel table.
Okay, this was scheduled for an exam on a weapons charge. My understanding is that we are ready to proceed.
Yes, the people are ready to proceed, Your Honor.
Likewise, Your Honor.
Any preliminary matters?
Your Honor, we have been able to obtain a copy of the defendant's conviction that establishes his disability.
This is just, you did come up with.
We did.
Okay.
So we wanted to admit that.
Thank
I've
you.
seen it, Your Honor. It is certified. Therefore, for purposes of preliminary examination, no objection.
Thank you. Any other preliminary matters?
No, people are prepared to call us first witness.
You can call your witness.
Your Honor, if we could have a witness sequestration order. just for the
Registration is
purpose-
ordered. This officer witnesses only, correct?
No, there was one.
There's a lay witness?
Yes,
Okay, how many witnesses do you have?
2, Your Honor.
Okay, sounds good. There's no witnesses in the courtroom, correct?
No.
You can proceed. You can have a seat, sir.
People call Detective Troy Johnson to the stand.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, I do.
You can have a seat. If you could state your first and last name and spell both.
First name Troy, Troy, last Johnston, Johnston.
You can proceed.
Thank you, Your Honor. Officer Johnson, are you currently employed?
Yes, I am.
Where are you employed?
I work for the Michigan State Police.
And what is your assignment there?
I'm a detective assigned to the Lansing Major Case Unit.
And I'm gonna take you back to June of 2025. Were you working in your current capacity at that time?
Yes, I was.
And I want to speak with you about, well, at that time, were you involved in an investigation of a shooting that occurred at the Sunoco on 1700 Willow?
Yes, I was.
Is that in the city of Lansing,
Yes, it is.
the Ingham County,
Yes,
state of Michigan?
yes.
Okay, so I want to just talk about your involvement in that shooting. How were you made aware of that shooting?
I was contacted after hours by Detective Sergeant Jason Spolma, works for the Lansing Police Department. I was called in to assist in the investigation.
Okay, and when you got that call, what did you do?
I interviewed a couple of people ultimately and also secured surveillance video from the Sunoco gas station.
And did you have an opportunity to view that surveillance video?
Yes, I did.
Other than the surveillance video, what type of participation did you have in the overall investigation of the shooting?
Just assisting in the identification of involved people and, like I said, interviews, assisting with the search of the house.
And were you able to make an ID of anyone?
Yes.
And how were you able to do that?
Through the surveillance video at the Sunoco gas station, produced an image and we were able to other officers had prior dealings with the subjects involved through running lean. They ran lean and which produced an image. And I was able to, that image was shown to me and I was able to clearly see that that image matched what I was seeing in the surveillance video.
And how were you able to do that? Was there any unique characteristics from the individual that you saw that helped you make the ID?
Yes.
Could you just describe those in general?
Sure. And I'm all right. Am I correct in saying that we're talking about Mr.
Yes.
Robinson Johnson? So his physical characteristics, height, weight, skin color, and his abnormalities with his eye allowed us to clearly see the and make an identification.
And based off of your observation of the video, your background investigation, you were able to identify the defendant, correct?
Yes.
Well, that individual, is he seated in the courtroom today?
Yes.
Can you point him out and identify an article of clothing?
Sure. He's seated over here at the defendant's table with a black quarter zip polo sweatshirt.
Okay, thank you. Let the record reflect that Detective Johnson has identified the defendant for the purposes of his investigation.
The objection to identification.
For the purposes of the prelim, no objection, Your Honor.
Identification is noted.
And let's talk about this video that you gathered from Sunoco. You said you had an opportunity to do that, right?
Yes.
How did you collect that video?
They have an on-site DVR at the Sunoco gas station. So I was able to access the DVR and they had footage saved from the incident. And I was able to pull that off and store that on some drive.
And if I showed you a copy of that video, or a snippet of that video, would you recognize it?
Yes.
Your Honor, as a matter of procedure, I've seen the video, and for the purposes of the preliminary examination, the defense has no objection to the admission of that particular video.
How is it marked?
People's zone proposed exhibit 1A.
People 1A is admitted by stipulation.
Can we be let into the Zoom to so that we can play that video? Dr. Johnson, I'm going to play a portion of this video and then I'm going to have 2 follow-up questions after we I'm going to proceed to what's on the video at 1:40, and I'm going to start there. Officer Johnson, do you recognize this video?
Yes.
How do you recognize it?
Well, I recognize it as being one of the videos that I pulled off of DVR from the Sunoco gas station. I know that camera is facing west.
And I'm stopping at 1 minute and 49 seconds. Do you recognize the black SUV that's in this video?
Yes,
How do you recognize that SUV?
I recognize it because we identified it. We identified it from the plate. We can see that Robinson Johnson exits that vehicle.
Okay. I'm gonna continue to play the video. I'm gonna stop it at, I'm gonna stop it at 3 minutes and 10 seconds. That individual there, that's in the white shirt.
Yes.
Were you able to identify that defendant or that individual?
Yes, sir.
And was that, did you, based on the information that you gathered in your investigation, was that defendant, was that individual in the, that you see on the video, was that defendant, Mr. Johnson?
Yes, it is.
I'm gonna back it up just a little bit. Pause it at 6 minutes and 15 seconds. The individual in the white shirt, we previously identified that as Mr. Johnson, correct?
Yes.
And I'll pause it at 6:52. And at this portion of the video, it appears that Mr. Johnson is speaking with the front seat passenger. Is that correct?
That's correct.
I'm gonna pause it again at 6:57. And can you describe what happens there at 6:57?
After the conversation with Mr. Robinson Johnson, you can see the front seat passenger lean out of the vehicle and partially exit the vehicle, raises a gun and starts shooting.
And the gun is, we can see, or can, from the video, do you see that the gun is in the individual's hand?
So I can't see it from here, but I've reviewed this video enough times. Yes, you're able to see the gun.
And there at 7 minutes, the individual gets back into the black SUV, right? Still with the gun in his hand.
Yes.
And Mr. Johnson, and then what does Mr. Johnson do?
He gets into the driver's side and drives away from the black SUV.
And I just want to play a little bit more of this video.
Before you do that, please just back up again to when the person that identified Mr. Johnson exited the store again. No.
And just, and it appears that the driver of the vehicle, which we have identified as Mr. Johnson, then places the SUV in drive and speeds off at a high rate of speed. Is that what we see on the video?
Yes.
Now, and you collected that video as evidence in your investigation.
Yes.
And then tell us what happened after you collect this investigation. What other participation did you have in the investigation?
So from here, we checked the flock cameras like license plate readers throughout the city. We're able to identify the same vehicle that hit off of one of the flock cameras. Ultimately, we were able to put it down at an address on West Holmes. A search warrant was written for that property, and we searched that property. And this is where I interviewed a couple of subjects on that lived neighbors to that property. So,
And were any of those neighbors or the people that you spoke to, were they connected to Mr. Johnson?
no,
Did you ever recover the weapon in this case?
no.
We have no further questions for this witness.
A cross-examination.
Thank you. Morning, Jackie.
Morning.
It's been a while since we last saw each other.
Yes, it has.
Good to see you again. All right, Detective. So obviously enough, you're investigating this incident, correct?
Yes.
I'm not going to go through everything. I'm just going to go through some of the highlights of the video. Okay. All right. Now, just to establish this, you reviewed this video. You know the contents of the video, correct?
Yes.
And you've also viewed other videos associated with this incident, correct?
Yes.
And you're familiar with those videos as well, correct?
Yes.
Okay. All right, Your Honor, for the purpose of the record, I'm using People's Exhibits 1, and I'm just backing up here. All right, Detective. Kind of pulling this back to the beginning of where we see Mr. Robinson Johnson. Detective, at this point in time, do you see a firearm anywhere?
No.
All right. Now, I'm stopping this exhibit at timestamp 3:08. At this point, we can see Mr. Robinson Johnson almost a full frontal view of him, correct?
Correct.
In his right hand, do you see a firearm?
No.
In his left hand, do you see a firearm?
No.
Okay. Do you see a firearm in his waistband?
No.
Now, we see him holding some items. I've stopped the video again at 3:10. We see some items in his hand. Do you remember what those were? Can you identify what they are?
I don't remember.
It looks like in his left hand, he's holding something square, presumably a cell phone. Would that be about accurate?
That's possible. I can see that now.
And it looks like he's in his right hand, he's holding something that he had picked up from the ground, presumably trash, correct?
Correct.
And he put something in the bin, that would be the trash, correct?
Correct.
Okay. And again, we don't see a firearm on him at all, correct?
Correct.
Continuing to play the video for the record, Your Honor. Now, we had just seen him go back to the car, and I've stopped the video at 3:24. He did not, he closed the door, correct?
Yes.
And even while he's at the car, he did not retrieve anything, just close the door, right?
It did not appear that he did.
All right, now at this point, he's entered into the store, correct?
Correct.
And for the record, that's at 3:29. I'm advancing the video here, Your Honor. Now, at this point, I've stopped the video at 5 minutes and 59 seconds. We see a gray car drive up, correct?
Correct.
You investigated that car, correct?
Yes.
There are eventually going to be two individuals exiting that vehicle. Is that right?
No, there's three.
There's three. My apologies. Thank you. All right. This person here, do we know who this is?
No.
Okay. He appears to be a United States postal worker. Is that about accurate?
Possibly.
Now, this individual here at the bottom of the screen, you investigated him, correct?
Yes.
Do you know who he is?
I know that he's in the report. We identified him.
All right.
So you know that he's what?
He's in the report. We identified him.
Oh, well, you don't remember his name.
Davis was the last name. I think they were both Davis.
Okay. Now, just to be clear, I've stopped the video again at 6:15, timestamp 6:15. At this point, we do not see Mr. Robinson Johnson, correct?
Correct.
He's still in the store, right? So these are the three individuals that, sorry, I've stopped the video at 6:20. These are the three individuals that exited the gray vehicle, correct?
Yes.
And the person at the very top wearing the white shirt, that's a female, is that correct?
That's correct.
And the other two were the two males that you later identified, correct?
Yes.
Now, to be fair, at this point, we don't see any firearms, correct?
Correct.
And for the record, I've stopped it at 6:24. Now, at this point, the two male individuals that exited the gray vehicle, they're going into the store at this point, correct?
Correct.
That's at timestamp 6:28. Detective, there's somebody, stop the video at 6:36. There's somebody exiting the black SUV. Did you ever find out who that is?
No.
The record, I'm letting the video play a little bit longer. Okay. Now, at this point, I've stopped the video at 6:50. At the top right-hand side of the screen here, we see Mr. Robinson Johnson exiting the store, correct?
Correct.
Do you see anything in his hands?
No.
Okay. No weapons of any kind, correct?
Correct.
Now, at this point, I've stopped it again at 6:51. Mr. Robinson Johnson is at the passenger side of the black SUV, is that correct?
That's correct.
Yeah. And at this point, this is where there's some kind of a conversation between the passenger and Mr. Robinson Johnson, right?
Right.
At 6:51, do you see a weapon?
I can't see it from here. You might have a better view. I think it comes later when you
Okay. That's a good point, Detective. Actually, at 6:55, what are we looking at here?
We're looking at the passenger stepping out of the vehicle and firing shots at the person who's now on the ground.
Okay, person that's now on the ground, that is not Mr. Delonte Robinson Johnson, correct?
That's correct.
And what do we see Mr. Robinson Johnson doing? He's ducking, isn't he?
He's starting to move towards the front of the vehicle.
Okay. Head down in a crouch position, correct?
It's difficult for me to say if that's a duck or if it's just him beginning to run around the vehicle.
All right. Now, at this very moment, he is not brandishing a firearm, correct?
Correct.
Sorry, Mr. Robinson Johnson is not brandishing the weapon, correct?
That's correct.
At this point, it is the passenger who has pulled that out of his waistband, right?
He's pulled it out. I don't know if it came out of his waistband.
Let's back this up a little bit. So I've backed up to 6:55. Now, going over, oops. Going back over this video, Well, let's put it this way. Who had the firearm?
The passenger.
Passenger, okay. And the passenger pulled that out from somewhere on his person, right?
Correct.
Now, at this point, I've stopped the video at 6:56. Mr. Robinson Johnson is now at the front of the vehicle, correct?
Correct.
And he's running, right?
Yes.
Stop the video at 6:59. Now, at this point, Mr. Robinson Johnson is getting into the driver's side of the vehicle, correct?
Correct.
Does Mr. Robinson Johnson at any point brandish a firearm?
No.
At any point in time during any of this video, did you see Mr. Robinson Johnson with a video, excuse me, with a firearm?
No.
Now, sorry, I stopped it at 7 minutes exactly. We had just seen the person in the black shirt doing something. What did we just see him doing?
He was firing rounds from his gun back towards the black SUV.
Okay. So the individual wearing the black shirt, he's returning fire at this point, correct?
Yes.
Detective, you saw a video from inside the store as well, correct?
Correct.
At any point in time, did you see Mr. Robinson Johnson, specifically him, with a firearm inside the store?
No.
So,
No.
Okay. Detective, you said that you did some follow-up investigation with regards to the vehicles, correct?
Correct.
Okay. The black SUV that we've seen throughout this video, do you know who that belongs to?
I don't remember who it was registered to, no.
Okay.
I wasn't the lead investigator on this, so I wouldn't say that I'm all knowing on this investigation, only the parts of the video. Interview of the neighbors.
That black SUV is not registered to Mr. Devontae Robinson Johnson, is that correct?
I don't know. Like I said, I don't remember who it was registered to.
Okay. All right. Thank you, Your Honor. Nothing further.
Can you correct?
No, nothing.
Can you go back to 6:55 for me, please? Okay, right there, you can stop. A detective, correct?
Yes.
Okay. The young man that has the black hoodie at this point, is it your understanding that he pulled the firearm out? Because when he falls, I see a firearm on the ground that no one's mentioned. So is that your understanding from your investigation?
So I can explain this a little bit.
Thank you.
We didn't cover it, but so in the store, you can see that the young man in the black sweatshirt has the gun. He has it tucked under his armpit.
Okay.
And so
Tucked under his armpit?
Under his armpit. Yeah.
Okay.
Like he's squeezing it right here. He's holding it. And so when he exits, I don't remember if we were able to see him grab the gun before the passenger starts shooting.
But it was under his armpit.
What's that?
It was under his armpit in the store.
Yes.
Got it. Okay.
You can
I'm trying
clearly
to
see it
understand
from
where
the
this firearm came
in-store
from that's
camera.
on the ground. Okay, thank you. Any cross-examination based?
But that young man didn't fire first.
No, he did not.
It was the individual from the car that the defendant was
The
in.
passenger.
That's correct.
And the passenger initiated the gunfire. And then, to your understanding, you've had a weapon. You carry a weapon.
Yes.
And when you fire a weapon, that the noise that it makes is loud.
Yes.
So everyone around in this video would have heard the shots being fired.
Yes.
Right. And then after Mr. David Robinson hears these shots, he hightails it to the front of, to the driver's side
Your
of
Honor,
the
at this
vehicle.
point, I'm gonna object, not only
Or-
is this leading,
I'm sorry.
but I mean, the people are essentially testifying to this.
This is leading.
So after,
Objection sustained.
Thank you.
after the shots start, you can see Mr. Davison.
Well,
go-
it's still leading.
Robert, what does Mr. Robinson do?
After the shots, he's running around the front of the vehicle to get into the driver's side.
Okay, nothing further.
The court asked, very properly with regards to the firearm that was not initially covered. Let's be specific here. Which one of these individuals had the firearm under his armpit?
The subject we see with the black shirt.
Okay, that, I want to be very clear here. That is not Mr. Devontae Robinson Johnson, correct?
That's correct.
Okay, and when you reviewed the videos inside the store, Mr. Robinson Johnson is not seen with a firearm, correct?
That's correct.
He does not have it under his armpit, correct?
Correct.
He does not have it in his waistband, correct?
That's correct.
Okay. Thank you.
No further questions.
Okay, so back to my original question. You did explain that it was under his arm, but you can't determine from your investigation if at this point, at the 6:55 point or 6:58, I would suggest, that the man with the black hoodie, you don't know if he pulled the firearm or brandished it at all.
Well,
Because from this vantage point, we can't see, but I don't know if you've seen the other.
there are other videos to show that he did not raise the gun and point it at anybody at that time. And you could clearly see that he had a gun in the store.
Right, but I'm not asking if he raised the gun or pointed at anyone. But did he have it in his hand?
He had it, he did not have, I don't believe he had it in his hand as I remember. I think it was still under his arm where he had it.
You've seen video that would suggest that, or
Yes.
you just can't recall? Is that what you're saying?
Right.
Okay, I'm gonna go this way so that you could be last, okay? And
I
you
just want-
redirect based on my question.
Yes, thank you, Your Honor. I just want to be really clear that the person that we're talking about at this very moment is not Mr. Devontae Robinson Johnson, correct?
Correct.
Thank you, Your Honor.
Thank you, Detective Johnson. You can call your next witness.
People call Mr. I'm gonna butcher his name. Here.
However you think it's pronounced, he can correct you when he comes.
Chaudhry?
Akbar Chaudhry?
Akbar Chaudhry.
It's noted on the complaint. Solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes.
You can have a seat. There is a microphone that's in front of you. The purpose of that microphone is so that the recording system can pick up your sound, but it will not amplify your voice in the courtroom, okay? So if you want to keep your voice loud and clear, that would be wonderful. If either of the attorneys say objection, that's because I need to make a ruling on whether or not you can give the answer to the question or not. So you would stop speaking and allow me to do that, okay?
Okay.
If you don't understand or you need something repeated, you could always ask for that. All of your yes or no questions, the answers must be yes or no. We can't do head nods or shakes, okay?
Okay.
If you can state your first name and then your last name and then spell both of those names.
First name is Akbar, AKBAR. Last name is Chaudhry, CHAUDHRY.
Thank you. You can proceed.
Thank you, Your Honor. Mr. Chaudhry?
Yes.
I am gonna ask you a few questions about an incident that happened at Sonoma.
Sure.
Are you currently employed there?
Yes.
How long have you been employed there?
14 years.
14 years, okay. So I'm going to direct your attention to June 17th of last year. Right? It's a long time ago, right?
Yeah.
I'm going to direct your attention to approximately 2:15 on that, on June 17th. Were you employed and at the Sunoco at that time?
Yeah.
And what were you doing at the Sunoco at that time?
We work in a register.
Register?
Cashier. Yep.
Cashier. So what do you do as a cashier? Just describe a little bit of your duties.
I take a customer, anybody buys stuff and look at and price everything in the right, then people buy and to go.
Okay. And around approximately 2:15 on that day. And is your Sunoco in the city of Lansing?
Yeah.
In county of Hingham?
Yeah.
State of Michigan?
Yeah.
So on the 17th at around 2 o'clock, did you come in contact with an individual that's present in court today?
Yeah.
Can you point him out and identify an article of clothing?
He gave me paper, then as my informant is coming 8:30, then I came here 8:30.
My question is, we're talking about June 17th of last year.
Yeah.
At around 2:15.
Yeah.
The reason that brings you into court today.
Because the video show up.
Yes.
That's why.
So my question to you is, was there anyone?
That happened, that's why I came here. That.
Right,
Yeah.
right. So my question to you is, was there anyone that you remember from that day, June 17th,
Yeah.
that's in court today?
Yes.
Okay. Who is that individual? Can you point that individual out?
Individual that it happened, I work over there, that's why I witness over there. That's why I came here today.
Let me try this another way. You were working at 2 o'clock.
Yeah.
Was there a time that came around 2 o'clock where there was gunfire at your store?
I heard that. Outside I heard that. Then I look at video too. Then somebody tried to shoot other people.
Was the
I
gunfire
don't know.
loud?
I have no clue what he just said.
Yes, a lot.
It was loud?
Yeah.
And you were there?
Yeah, I work in just at that time.
I'm sorry, the court was indicating, I'm sorry.
Yeah, I didn't know what his answer to that question was, so I don't know. That it's, I mean, if the answer was supposed to be meaningful, it didn't help me.
It wasn't me.
Okay.
So y'all know there was some gunshots, right?
Yeah.
It was loud.
Yeah.
You were working at the register.
Yeah.
And there was a person that was in your store that day, right?
Yeah.
That's seated in that is in the court today.
Yeah.
Who was that individual?
Any people here?
Yeah.
That guy buys stuff inside in my store.
Right.
Yeah. He buys stuff and going outside.
Yeah.
Somebody tried to shoot. I don't know. He shoot. Somebody him shoot. I don't know. Because I pay attention to other customers.
Okay.
Yeah, I heard that in shooting. That's it.
Okay. Yeah. But Your Honor, would we please be able to so before I ask that, so just to be clear, the individual that you pointed out over there sitting next to the defense counsel.
Yeah, he buys stuff.
Was in your store.
Yeah.
On June 17th.
Yeah.
Before you heard the gunshots.
Yeah.
And did he leave? How long before the gunshots was he in your store?
I think around 4 or 5 minutes.
Okay, and then he left?
Yeah, he buys stuff and
And then you heard the gunshots?
yeah.
Okay. Your Honor, I would like.
You know, as a
No,
I
no,
think, oh,
you're
okay.
fine. Your Honor, I'd like to please let the record reflect that the witness has identified the defendant, Mr. Robinson Johnson, as the individual on June 17th.
Any objections to identification?
For the purpose of the pre-one, no.
Noted.
No further questions.
Thank you. Good morning, sir.
Morning.
You said that you heard some shooting, correct?
Yes,
You heard it from inside the store, right?
not inside and outside. Shooting in outside.
Shooting is outside.
Yeah,
Okay. You were inside the store.
I work in inside and just,
Okay. You didn't see who was shooting.
no, I see in video. Then boss gave him video, his video is correct.
Okay.
Yeah, I never seen outside who that shoot it. Then I see in video, then it's clear, everything right.
Okay. But
Yeah.
you yourself did not with your own eyes see who shot who.
No, I know that.
Thank you, Your Honor. Nothing
Yeah.
further.
Ladies, witness,
No,
yes. Oh, you have
yes.
some more questions?
No, no further questions.
Thank you, Mr. Chaudhry.
Thank you.
You're welcome.
Yes, thank you. You can leave now.
Thank you so much.
Thank you. Any more witnesses?
No, Your Honor.
Any defense witnesses?
None for the defense, Your Honor.
Argument.
People move to admit the video evidence.
It's been a minute.
Yes, okay. Your Honor, in this case, Mr. Robinson Johnson is charged with carrying a concealed weapon. I think what the issue comes down to in this case is about carrying, what that means. In order to prove this charge, the people have to prove that the defendant did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant. And our argument for count one is simple. We saw the video, we heard testimony that the defendant exited the driver's side of his vehicle. He went inside the store for 5 minutes or so. He came back out. There was a conversation between himself and the passenger. At some point, the passenger of his vehicle produced a weapon. Shots were fired. You heard testimony that gunshots, and I'm sure just as a regular normal person, gunshots are loud. As you saw from the video and you heard from the testimony, the individual that brandished that weapon and shot that weapon then got back into the car. Mr. Robinson Johnson got back into the driver's seat of the car, and that weapon was transported away. He drove away at a high rate of speed after this concluded. So our argument is simply not that he himself possessed the weapon, because I don't believe that is solely what the sole basis for what we need to prove in order to find him guilty of. We just need to know that he was aware that there was a weapon in his car and that he drove that car with that weapon in it, and it was inside the car. So clearly from the testimony that you heard, there was loud gunshots. He saw the gunshots, he ducked, he ran to the driver's side of this vehicle. He saw his passenger with that gun go back into the vehicle. He could have said, "Hey, I'm not driving this car with this gun. I'm walking away."
He could have said that.
He could have did that, but
and then what could have possibly happened if he didn't get back in the car and retreat, based off what we saw?
I'm sorry?
We saw the video together.
Yeah.
And that was going to be my question to you. What was the options during this time? And when you see your passenger pull a gun, shoot at an individual, we now know also has a firearm. I'm sorry, are you under her supervision or is she under yours? Okay, because I'm talking to you and she's talking to you too.
He just wants to help you.
Okay, what was his options? If he sees this passenger pulls a firearm, shoots at the subject, and then we now see that the subject, and we know from the officer's testimony, had a firearm either at this point in his, at least under his arm, possibly officer couldn't remember it, in his hand, who knows? But then it falls and then this person shoots back. What is the, what was the defendant supposed to do? Is he supposed to stay there and not get in the vehicle and then possibly get shot?
Well, again, I believe that's a matter for trial, but.
Is it?
He could have.
That's not a question of fact for any of these elements.
He could have run away.
Because you were the one who said what he could have done. So I'm asking you, well, yeah, but wouldn't that have put him at risk for getting shot? You were the one who introduced that he could have done that.
He could have run away. He could have ducked.
He could have ran down the street.
He could have ducked underneath the car.
Ducked up. Okay.
Under the front portion.
Absolutely.
But again, he decided to get inside the car where there was a weapon. He knew that there was a weapon inside the car. After that, hearing shots with the weapon, after seeing his passenger make shots and get back into the car. So again, under at least the theory of constructive possession, Mr. Robinson took control of the car with the gun and he transported that gun away. And for that reason, we ask that you hold on the probable cause standard that he operated a motor vehicle or occupied.
He was in a motor vehicle that he knew a pistol was in and that he took part in carrying or keeping.
Yes, we're gonna ask that you hold it.
Mr. Basiga.
Thank you, Your Honor. Certainly, I'm not going to belabor the point. Court has seen the video. My submission, I think it's, well, first and foremost, there's no evidence that Mr. Robinson Johnson had any knowledge that there was a firearm in the vehicle before the shooting. To the extent that there's any knowledge of the firearm after the shooting, I'm simply going to say, Your Honor, at that point, I think it's endemic to anybody who's been shot at or in the middle of a shooting, the fight, flight, or freeze response is going to take over. To the extent that there is any, I'm going to go back to criminal law 101, and to the extent that there's any level of mens rea, there's been no showing that Mr. Robinson Johnson had the criminal intent of literally possessing or even constructively possessing a firearm. At that point, gunshots are being fired. He's trying to get out of the way. He's trying to not to get killed, Your Honor. So when it comes to that mentality, when it comes to that mens rea, I don't believe that people have shown any evidence of criminal intent. I would ask the court to dismiss this case entirely.
Today was the date scheduled for preliminary examination. The burden is on the prosecutor to establish the evidence to a probable cause standard that you, Mr. Devontae Robinson Johnson, took place in carrying a concealed weapon. And it's more than mere suspicion is all they have to show. They don't have to prove each element beyond a reasonable doubt. This is not a trial. But the court at this time is in the position to weigh the evidence and measure whether the evidence raises reasonable doubt about your guilt and to measure the people's probability of success if this were to go to trial. I'm also in the position to weigh the credibility of any of the witnesses. So this is a common sense standard. It's flexible. It's based on the facts and circumstances presented at today's examination. We had testimony first from Detective Troy Johnston. He testified that on or about June 17, 2025, he was contacted after hours by Detectives Jason Spoma about a shooting that had taken place in the area of 1700 West Willow. That's in the city of Lansing, Ingham County, which makes the venue in this court appropriate. He was contacted to assist with an investigation. He did make it clear that he was not the lead investigator, he was assisting. But just for the record, the court found the detective's testimony to be completely credible. He testified that he interviewed some people in the area. He secured some surveillance to which the court had viewed, and it was admitted under People's Exhibit 1A by stipulation. That was a video that was procured from the Sunoco gas station at that location. In viewing the video, you see a black SUV pull into one of these bays at the gas station. You see a gentleman exit. He's wearing shorts. It looks like some white and gray Jordans. His hair is similar to how the defendant's hair is worn today. And he's maybe cleaning some things out of his vehicle. Very casual situation. Then he goes into the inside of the gas station. Shortly thereafter, you see another vehicle pull up behind the defendant's vehicle. I'm going to be very frank in watching the vehicle, because I think there was like some dead areas. Like, I'm like, what are we watching? Not much going on at first. It wasn't until this next vehicle appeared and the three people get out the vehicle that it was immediately apparent that there's some trouble here, or going to be some trouble. In the manner in which these individuals are just carrying themselves, and made it clear that that was going to happen. That there was some guy who didn't even have a shirt on, I think a young lady and another young gentleman. They go into the store. You see later they exit around the 6:58 mark. I don't know, because there's no sound, whether or not there's words exchanged. It should be noted that the court also saw that there was a passenger. The first time the court realized there was a passenger was when these individuals in the car behind pull up. The passenger seems to crack open or open the door slightly. I don't know if the passenger knew who these individuals were, or if there was some concern of some sort. That's beyond me. But I do know that that was when the court first realized there's even a passenger in the vehicle. The parties, the defendant is seen exiting the vehicle, exiting the store and heading towards the vehicle, or having a brief conversation with, I believe, the passenger of his vehicle, or the vehicle he's operating, because it was testified that the vehicle was not registered to him. When the other individuals that were parked behind the vehicle that the defendant was operating are seen also exiting, and an interaction takes place between the passenger of the defendant's vehicle and the vehicle, the people that were in the vehicle behind the defendant. That interaction doesn't appear long, but there you can see the passenger of the defendant's vehicle jump up out of the vehicle with a firearm, and it appears that he shot at the subjects, or one of the subjects from the vehicle behind that vehicle. That subject was wearing, I believe, some tan shorts and a black hoodie. When that subject fell to the ground, the court could see what appeared to be a firearm fall right next to him. At this time, it should be noted that even before the subject had been shot, if he was shot, it's unclear, and fell, that you could see that the defendant in the video appears to be immediately on guard. The direction that he appears that he's looking at is at the person with the black hoodie. It was questioned to the detective if the person appeared, if the defendant was ducking or running. The detective said he wasn't sure if he was ducking or running. In your argument, you admit he's ducking. He's running towards the vehicle, the passenger vehicle, immediately as shots are fired, and the subject on the ground releases a firearm. Shortly after that subject's on the ground, the video displays that subject pick up a firearm and it appears he shot back at the vehicle. We see the vehicle leave. It's stated that the vehicle left at a high rate of speed. And it sounds like that this vehicle was later recovered. The firearm, however, not being recovered. The people are arguing that by the way of constructive possession, that the defendant should be charged with carrying a pistol in a vehicle, and that there was a pistol in the vehicle that he was in, that he knew that the pistol was there. And third, that the defendant took part in carrying or keeping the pistol in the vehicle. And then obviously, Mr. Basiga, the defense counsel, objects to that and believes that this is a matter that should be dismissed because of the circumstances, and that primarily his client lacks the requisite mens rea to carry a pistol, or lack the requisite mens rea to carry a pistol in the vehicle at this time. This is the concerns that I wrote down. One of those questions I was going to ask the prosecutor during the argument was, what was the defendant supposed to do in a situation like this? There's no evidence here on this record that would show me that the defendant knew prior to this incident that there was a firearm in the vehicle that he was in. There's no evidence that shows me that prior to this incident that the defendant knew that there was a firearm, or that he was doing anything to take part in carrying or keeping the pistol. The only thing I have now is that there's an incident that appears, based off what I see, to catch this defendant off guard. And that this defendant is ducking, and he's ducking not from the person he's next to, because he's looking in the direction of the person with the black hoodie, which the officer says a firearm can be seen under his arm while he's inside the store. So if an officer can see this firearm while he's inside the store, it's not beyond me to believe that no one else outside can see this firearm under this person's. I don't know if it was still under his arm at the time, or if it was later in his hand. All I know is that these two individuals that doesn't include Mr. Johnson, are having an interaction that appears to be heated, and then shots are fired, not from Mr. Johnson. It's only after that incident, when Mr. Johnson is retreating to the vehicle that he is operating, as shots are being fired at that vehicle, that I am questioning what was his recourse. Is he supposed to wrestle the passenger in his vehicle out of the car, even though that passenger is obviously carrying a firearm? Is he supposed to is he supposed to run back towards the person who's now shooting in their direction? Is he supposed to run down the street and leave the vehicle that he is operating? Even if there were any of these options, I believe were reasonable, and I don't believe any of those options were, I would have to believe that in a split-second incident, I don't know if any of you all have been in a situation where shots are fired and you're there. I have. And when that happens, your mind goes blank. I have been in a situation outside of my control where shots were fired in one direction, and there are people right here are about to fire shots in the other direction. When I heard the first shots, I went blank. I'm with my older sibling she knows that they're going to return shots. I don't even know how I got there. I ended up on the ground. She had pushed me on the ground. I say all that to say is, when you're in certain situations and when guns are being fired, you can't decide in your head that, you know what, I probably don't want to keep this guy in my car because I could be perceived to have been keeping a firearm in my vehicle, even though that's not what's being suggested here. What's being suggested is that he now knows that his friend or whoever's in the car has a firearm, and he didn't get him out the car. I don't believe he had a duty or responsibility in that time to do that. I think in that time he had a duty to retreat for safety. There's firearms, there's weapons being discharged, and it's not by him. And there's no reason for me to believe that he knew that weapons were going to be discharged based off of how that interaction played out. He went in the store, he came out, and he's having a conversation when the other two end up going back and forth, and he's ducking and running. No reason for the court to believe, and no evidence on this record that supports that he took part in even understanding what the interaction was. Just that he should be responsible because he drove off and that person was still in the vehicle. I believe he's guilty of keeping bad company if he's hanging out with people who unlawfully have firearms, but I don't even know if the person unlawfully had a firearm. I don't know that. I know nothing about who this passenger was. I don't know if the firearm was pointed at this person first and this was a self-defense. We know nothing about that. All I know is that there was an interaction that was not taken at his bequest, and that he pulled off, and I'm not going to find him responsible for pulling off while gunshots are being fired in his direction, because the person who was the passenger also got in the vehicle. I don't think he has a duty to stop right then and wrestle this person out of the vehicle, nor did he have a duty to hide under the vehicle, because that sounds ridiculous in this circumstance. Nor do I even know that he could get under the vehicle, judging by his size, but that's a whole nother issue. Nor did he have a duty to run down the street. I think this is a poorly charged case. And for those reasons, I also agree that he lacked the mens rea. There's nothing here to show me that he had a guilty mind or that he really took a guilty act. I'm not going to constructively hold him liable to someone else's carrying a firearm that it doesn't appear to me he had knowledge of. For that reason, the case is dismissed.
Thank you, Your Honor.
Here is your order of judgment back, and we'll get you a copy of dismissal in just a moment.
May I approach?
Okay.
Your Honor, my client has a tether. I'm presuming that he can go into that.
He needs to go back to JSG or to Ingham County to have it removed. We'll notify them.
Thank you, Your Honor.
Thank you. And then we have one more person that needs to be brought up.
Yes, Judge.
I'm assuming this is your client who's tardy. Yeah, I'm assuming this is your client who shows up when he feels like it. It's Judge Simmons to you. Why are you late?
I actually was preparing for this day. I was working really late, well, early, I should say, till 7:30, and I burned my ass welding. It's still currently on fire, but I laid down in the car trying to pull my eyes down, and I woke up and it was 10 o'clock. Actually, video too. We got cameras at the shop. I really did not mean to miss this period.
Okay, I know that the victim was here, but we weren't supposed to have an exam. Is that correct?
That's correct, Your Honor. He's gonna wait for prelim. He's gonna waive his break to prelim, excuse me.
On the record in the matters of the state of Michigan versus Miguel Perez, 26-00021 and 26-00145 appearances.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people.
Early afternoon, Your Honor. Attorney Barnett will here again on behalf of Miguel Perez, who's president, standing in my way.
I'm just making sure it's birthdays are accurate, because that there was a note to confirm his birthday, but I do recall seeing him previously, and I think I confirmed it last time. Okay, let's see. There is a weapons possession by narcotics and felony firearm and file number ending in 21. And then there is weapons and file number ending in 145, and you would like to waive your examination in each of those.
Yes, Ms. Justin.
Okay, is anyone threatening you to do that?
No.
Any promises to get you to do that?
No.
You understand the purpose of the exam?
Yes.
Okay, so you have the right to require the prosecutor to establish that they have sufficient probable cause that felonies were committed and sufficient probable cause to charge you as the person who committed those felonies. You understand that?
Yes,
He understands it. You don't have to keep looking at him. I'm asking you, do you understand it? If you don't, you can always say you don't understand
I
it.
don't understand.
Okay, so probable cause is more than mere suspicion that something took place. It's not beyond a reasonable doubt. It's a low burden. So they just have to show more than mere suspicion that each of the felonies that you're being charged with actually took place. And then more than mere suspicion that you allegedly were the person who took those actions. You understand that?
Yes,
Okay. The purpose of a preliminary examination is to allow them to do that. Is that what, do you want to hold that hearing today or do you not want to hold that?
I mean, you know.
It's up to you. You have to waive the right. He can't waive it.
I'm like, no, not today.
You want to waive your right, because when you waive it, it's gone, and you can't go tomorrow and decide you want your right back. If you're waiving the exam, there won't be an exam. The cases will be bound over to the circuit court. If you get there, you don't like your offer, you can't decide, nope, I want my exam now. You understand?
I want my exam.
You want your exam. Is that what you want?
I mean, I'm not trying to make it any worse.
Make
You know
what
I'm
any
saying?
worse?
Like, this whole situation,
Okay.
you know, my pistol charges and all that.
Do you have an offer at all?
No, we were gonna do a global resolution.
Okay, he has other matters over there already?
No, the 2 files and then, but there's no.
Do you want your exam? Is that what you want? That's okay.
You have the right to your, that's your right.
Do you want? You can have
It's
it.
basically to examine the situation, right?
It examines the situation, but to a standard of more than mere suspicion. So they have to show more than mere suspicion that each of the felonies in this file that you're being charged with actually took place. So more than mere suspicion that you carried a concealed weapon on the date and time, more than mere suspicion of the other things.
Then, yeah, well, I'd like to. Okay.
Okay.
Your Honor, just for the
We're not prepared to do that today, though, are we? Because you
No,
released
Your
the
Honor.
witness.
Yeah.
We have to give you a new date for that because the witness has been gone.
And so I'm just going to withdraw my signature, just to be clear for the court. I know nobody's saying.
That's
this,
fine.
but-
You know, I'm not,
Okay.
I didn't sign it anyway. So,
Sure.
and I don't know if the prosecutor has.
And we did have prior exchanges, and so.
It happens all the time.
I appreciate it, man. Thank you.
Maybe it was just Ms. Judge Simmons.
Okay, let's quash the warrant and we have to reset this. Was there a reason why the victim was here? Because was it a regular DV?
Just a misdemeanor domestic.
Okay, so what she needed for some purpose? Okay, so the victim didn't need to be here anyway, it's just officers, correct?
Yes.
Okay,
May 8th at 9:30.
May 8th at 9:30
Thank you.
is your new exam date.
Thank you, Judge Simmons.
Does your attorney have your number?
Yes, ma'am.
Okay, so when he calls you, you'll answer.
Yes, ma'am. I even reminded him last night.
Well, he was here.
Okay, Your Honor, okay.
He was here,
I'm just saying, I was
but
working.
it doesn't matter.
I'm
He
just
was here
saying.
today
I know.
and
Your Honor.
he couldn't get in touch with you.
I understand.
And Your Honor, just to clarify what my client said, he reminded me, he sent me a text at 9:40 PM. Wasn't a reminder. It was just him saying hi. And then today I did call him half a dozen times. So I do have, and I texted him and we had, so
I'm
just
not-
to
I
clarify
believe it.
that, I'm not gonna throw my plan in the bus. I know he wouldn't do that to me.
I get it. We'll get you a notice in just a moment.
Thank you very much, Your Honor. I appreciate it.
Okay, and then
I
is
have
it
one other matter for the record
on this file?
on this file.
Yes.
It's been brought to the people's attention that the defendant may be having communication with the. So we just want to come to aware of that and ensure that he's made aware of his bond positions. Because if there's an investigation, we want to introduce him to new charges based on.
Well, all we needed is the allegations. We don't need an investigation. If the victim was here today, if she said that he's called her, she takes a stand. That's all it's required. So you're clear, I hope, that you're not supposed to have contact with the protected party, correct?
Correct.
That's directly, that's indirectly, that's through Facebook, that's
I did
through
not want to
text,
talk to her.
that's through DMs. You can't ask him to call her on your behalf. There's no contact. Do you recognize that?
Yes, ma'am.
Okay. It doesn't, I don't have a report or anything. All I have is what's being stated here. If they would like to move forward with the PA 53, they have the right to do that. At this point, I'm going to just remind you, which is what they're requesting, of your bond conditions. No contact directly or indirectly. I don't know her name.
Wow.
I'm sorry. Amanda Perez. Is that a yes?
Yes.
You are married?
Sure. Yes.
Yes, Your Honor.
Okay, I'm just asking because it's the same last name.
Your Honor, absolutely.
Okay, so no contact directly or indirectly with Amanda Perez, who's named victim here on the domestic violence case, okay?
Yes, ma'am.
It's for your own protection unless you want to be sitting in jail. I think you like your job, no?
I will not go to
Okay.
jail
It's-
forever again in my life.
I would hope that you wouldn't go to jail for anybody, but that's for you.
That was my
to
first
decide.
time and I'm almost 40.
That's for you, that's for you to decide if you want to go to jail.
Nope.
Any additional matters for the record?
No, Your Honor, thank you very much.
Thank you.
Thank you, Your Honor.
Thank you to the court for allowing him to come back and have us here.
I appreciate that very much. Thank you, guys.
I'm about to scream.
I know, I see.
I'm about to scream at you.
Does that conclude the docket?
That is not.
Oh, even just sitting back there.
Did Mr. Martinez leave the building?
Or was that a question for me?
Or anyone, does he know if Joel Martinez is still
I don't
here?
think he's still here.
Haven't seen. Everyone inside of the office, so is that the 5 hour and home? Yeah. Did you agree to requesting? Everyone's in training, so.
So the memorandum of understanding was sent out, does that mean they were accepted? Okay. So long story. She has a thing with everyone though, at some point. Mhm. You guys will be besties.
Is she like a vegan or something?
No, she kind of gives that.
Well, but people, vegans have very short, irritated really easily.
The nutrients.
Yeah. That's why I thought she.
She's just sensitive.
Mm.
But it was there was someone who seemed competent, on statutory time, and I'd never done that before. And so I emailed Joel to ask what to do, and I CC'd her on it. And she thought it was undermining that I would ask. She had a point. And a month later, it was when I first started, a month later, she brought it up and started raising it. It seems like somebody else would be happy.
On the record of the matter of the state of Michigan versus Michael Shulumba, 26-00574, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Jacob Riley appearing on behalf of Mr. Shulumba, who is present to my right.
Okay, this matter was scheduled for examination on receiving, concealing a vehicle, and then this is destruction of building misdemeanor. How are we proceeding today?
Your Honor, the people have offered in this case a deal to plead to count one under HIDA with restitution to the victims for their vehicle damage, and then plea, or we will dismiss count two, but we would like the defendant to pay restitution to Taco Bell.
It's a total restitution.
Taco Bell have a restitution amount. Give me a moment. I believe it's somewhere in our file. I'll have to get back to the court with the restitution for both the defendant, for the vehicle damage and the Taco Bell.
Okay, do you think we can get restitution hearing? Or is he just gonna agree to whatever the restitution is?
I'd like to see some supporting documentation of the amount.
Okay, so you're gonna plead guilty to count one, sir?
Yes, Your Honor.
Count one is a felony. Correct?
Yes.
Okay, well, if he's gonna take a felony plea in district court, it has to be scheduled. So we can't take it here today, because we have to schedule it, because we have to get a sentencing date. So you have two options. He can waive and then take the plea over there, or we can set it for a felony plea.
Yeah, so we'll just ask for a new date for the restitution
And plea. We can do April 16th at 9:30. April 16th at 9:30. Any additional matters for today's record?
No, Your Honor.
I'm gonna give you this file so you can get it set up for the felony. You're all set, thank you.